Welcome to the show from the University of Canterbury, Professor Ursula Cheer. Professor Cheer, fantastic name, by the way. I'm sure you get that all the time. Thank you for joining us.
Yeah, no, you're welcome.
I was writing the email to you, and I say cheers to people all the time, and I was going to say cheers, and so I said thank you or thanks or something. I changed the name around, so it's thanks.
No, look,
Ursula.
I sign off cheers all the time, and I often think people must think I'm crazy.
At the University of Canterbury, you are in the School of Law, and you are a media expert in law and defamation. And that's a really interesting conversation in and of itself, a defamation thing. We often hear about people saying, I've been defamed, but the standard being very high for proving what that is, and honest opinion being able to be used to get away from all of that. And that may have something to do with what's gone on in this story today about Sean Plunket. Very, very recently, at the time of recording this, we have heard that Sean Plunket is facing charges, has been charged, whatever the correct terminology is. Here, I should just bring it up, and I'm sure we'll have looked at this before we get to you, but is facing charges on, there it is there, and there it is there. There we go. Charged with publishing reports of restricted court proceedings. Now, our listeners and viewers know what this is about. It's about him basically being a dick towards David Farrier and trying to make accusations towards David Farrier based on things that were in a court document but have since proven to be a false allegation towards David Farrier. In releasing that information, he also released some of the names of the people in the document. Hence, I mean, I guess I got to be careful and say I'm assuming that's what it is. What else could it possibly be? But he says the official writing says broadcaster and founder of online news site The Platform, Sean Plunket, has been charged with publishing a report court proceedings without leave, which I just imagine saying is a legal way of saying without permission or without the right to do it or something like that, because of name suppression. I guess before we just ask any basic questions, you've read the story and we know the background of it. Do you have any thoughts around, especially from coming, because he's in media and you're an expert in media law, any thoughts around it in general?
Well, there are many risks around reporting court proceedings generally. So, but there is but the basic principle that's your starting point around reporting anything of that kind is open justice. And there's been plenty of case law that set that out. We're meant to be living in a system where the courts are run on our behalf by the government, and we're entitled to know what goes on in the courts, and that things that are adjudicated on and cases that are going on, all of them mainly are being done properly and appropriately. And in particular, obviously, the main area where this is sort of high profile is criminal justice, and where you're talking about crime and things like that. So that's why we've got general suppression laws around the criminal justice system. And suppression laws interfere with that principle about open justice for special reasons. They're regarded as good reasons in New Zealand, and they're reasons around where someone's facing a charge or is engaged in a trial around something they've been charged for, a crime. It would be harmful to them, shown to be, usually the standard is seriously harmful, for their name to be disclosed is probably the main area where there's the most sort of publicity around suppression. So it's quite hard for people to get suppression, especially permanent suppression after a case. They do get what we call interim suppression quite easily, and the idea of that is that if you're facing a charge or you've been charged, you should have a bit of time to maybe go home and tell your family what's happening and so on. And it's not till your next appearance in court that you then have to make good grounds to keep the suppression in place. But and there's quite a lot of contention, especially from media, about the suppression system generally, because obviously it restricts information that the media might like to publish, and so they're very vigilant about suppression cases and who gets suppression, and they media have the right to apply for suppression orders to be varied if they think there's good reasons for that. So it's kind of an intersection between the media doing its job and the court system. But what we're talking about here is slightly different, because it involves a special court, and that's the family court. So I can talk a bit more about the special nature of that, if that's what you want me to do.
Yeah, please do, because the article that David Farrier wrote about it as a journalist, he's like, sometimes you can kind of push suppression in the courts, but you don't go near family courts. That's like it's
Yeah,
like the sacred cow. You do
yeah,
not push boundaries there at all. So, but yeah, feel free to unpack that for us.
sure. No, absolutely right. I mean, in other cases, and in the criminal justice system situation, obviously media have to be very vigilant to check that there isn't a suppression order in place or still in place or whatever, and make sure they comply with that. It's not really what we're talking about here, because the family court is a special court. It deals with lots of sort of special jurisdictions around families and issues that can arise for families. So, I mean, it covers things like the Care of Children Act and Oranga Tamariki, those sorts of proceedings, Children and Young Persons Wellbeing Act, the Adoption Act. There's a whole bundle of special areas that come under the court's jurisdiction. And until 2005, that court was the most private court that we had in New Zealand. So you couldn't really report on anything that went on in the court. And in fact, media couldn't attend the court either.
Right.
And the reason for that was that it was recognised that it's a court where you've got extremely private matters that are being discussed, family matters, family disputes, disputes and issues involving children who are regarded as vulnerable because they're underage and can't really make decisions for themselves. So that privacy and that need to look after particularly children and other vulnerable people involved in family care type situations was not opened up to the media until 2005, and then things changed. And so now the media can be in the family court and they can report, but there are strong restrictions, as David Farrier has said, on what you can actually say. And the main thing to keep an eye on is not to identify anybody, not to anonymity is the key. Yeah.
And that's a place also where, like, if the adult has committed an act, like a violent act or something, they may get name suppression, but it's because of if the victim was a child, like saying a father XYZ, but saying the person's name, then you identify the child. So that's a place where even it's not the victim who gets the name suppression, maybe the offender does as well. And I understand that's pretty different from criminal court to family courts as well, because there are so many vulnerable children involved in the family courts, obviously.
Yeah. So what you have to worry about is not just that you're not identifying a particular person, particularly children. It means in not putting any information in your report that would allow that person or child to be identified.
Yeah.
So you have to take the extra care there around that. You're absolutely right. Yeah.
But a bit of a tangent. I mean, it's a silly tangent. I'm sorry, but this is kind of how
right.
I roll. I've always thought, I've worked in the media for a long time, right, since the late 90s, on and off. I've always thought that name suppression should be applied to everybody until a guilty verdict comes out. Because quite often, like, so you say it's kind of hard to get name suppression. I've always thought it should be really easy to get name suppression. And then when it's guilty, unless there's a child or something involved, no one gets name suppression. Because so many people, like, I'm exaggerating a bit here for effect, but had their lives ruined or whatever over a charge that's they're found not guilty of. I'm always thinking they should have had name suppression. Am I just being like rose-tinted glasses naive, or is that something that could happen one day?
No, in fact, some years ago, the Labour government was interested in that, but it never came to be. So that has been proposed in the past, and some people do think it's a good idea. I've, throughout my career, being involved in researching and following media law, I've often been contacted by people who are petrified of having their names come out in the media. And I've seen the real distress that can cause. Now, since the law was changed, and we're still talking here just about general criminal procedure and name suppression associated with that, 2011, that area of the law was amended in order to tighten up the rules, because it was felt that too many suppression orders were being made, and that there had to be some conformity around the way they were granted and so on. So I think that statute that was passed in, a special section put into the Criminal Procedure Act, was quite a good reform and actually has worked quite well. It has in fact reduced the number of suppression orders that are made. It is easier to get them at that interim stage I talked about. And then the idea is it's much harder actually to justify it. You have to come up with and have good reasons to go for whatever sort of suppression you're after that. So, and I'm inclined to believe that publicity around people who are charged with offending and so on can have really significant effects on the individual and or perhaps their family, their children in particular, if they're able to be identified through their parent and that sort of thing. So I think the distress and so on associated with this sort of thing is real. I think sometimes media are inclined to be a little bit harsh about it and inclined to assume that if a person has been charged, they're actually guilty. Now, the important thing is that you're mostly talking about a time when we don't know. They've been charged, they're awaiting trial. Now, of course, we've got another area of the law, the Contempt of Court Act, that covers fair trial and the need to have a fair trial, because obviously media coverage can negatively impact on how your trial is going, and perhaps if there's a jury involved, influence them in some way. So we do have that other area of the law, contempt, which a judge can use to try and ensure that the trial's as fair as possible, and that controls not only issues around naming somebody but other evidence coming out and that sort of thing. So there's another area of the law that's there, but it has to be said that those laws, and indeed the laws around breach of suppression, are used sparely by the state because it takes resourcing. The police have to, investigate and charge and so on. And what they try to do, because of limited resourcing, my impression at least is that they save those sorts of charging for offences for the worst cases, to make examples of them. So that's why when people say to me, well, it's not fair that the media has to comply with these rules, but people on social media don't. That's not true, of course. People on social media take exactly the same risks and can be charged as well. So the risks are there.
Well, that brings us probably nicely back to the actual conversation for today as well. If you've just made a mistake, like it would appear, and I'll say allegedly, it would appear that Mr. Plunket has used a felt tip and scrabbled over the names in an attempt to redact it. And then those of us who understand Photoshop enough, clever little clogs, have got it on the internet and taken it off and revealed the names. Is there a defence to say, oops, I didn't mean to? Or does that not hold water in a court of law, especially when we're talking about family courts?
Okay, well, it varies. And I'm looking at the relevant section, which is in the Family Court Act from 1980. And it says that people can publish reports of proceedings in the family court, but you may not, without the leave of the court, publish reports that include identifying information where a person's under 18 and is subject to the proceedings and so on, or they're a vulnerable person. It exempts what are called sort of genuinely professional and technical reports, that as long as they're anonymised, they can be published, and it gives the power to the court to grant leave. Now, in this case, as we know, no leave was granted. So there's no discussion in this section, as far as I can see, this provision that talks about what we call the state of mind, and there's no special provision of any defence. So it looks like what we call an almost strict liability offence.
Because if he hadn't have released the document with his redaction, then those names wouldn't be out there, even if the case law says, hang on, that was a whoopsie. Yeah. But without him putting those out there, the names wouldn't be out there no matter how they got out there from his document. He might have been
well-intentioned, and he might have done his best in the circumstances to try and redact it, as you said, without thinking what might happen. Who knows what his state of mind was, and that evidence might come out in the case. But assuming he was well-intentioned and did his best to limit it, and it's just through this unforeseen events and actions of other people that this has happened. It doesn't appear to be a special defence for mistake or anything like that. And things around his state of mind and his genuineness and his intention could really only be reflected in the sentence, any sentence that might be imposed. Yeah.
Right. Gotcha. As a media expert, or media expert in media law, I should say, from your perspective, what do media companies need to do to stay out of court? Like, we often hear about, there's this vibe at the moment about, public money, yada, 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 yada. Same people that say that about public money to do with media still like to go to their public health doctor and get their hearts looked at by public money. That seems to be okay there. But I've heard journalists say, for me to publish something, I need to write it. It needs to go to my sub-editor. It needs to go to the lawyers, and then it gets published. There's a layering of things. So
Yes.
from law and the media, what do media entities need to do? What should they do to basically stay out of court?
Look, I've just given a lecture this morning to some
Oh,
budding
nice.
broadcasters. And because what I was emphasising with them, and what I always emphasise in my lectures to students, whether they're law students or journalism students, is care, just extreme care. So that layering that you're talking about, that's a system that should exist. There should be care all the way along. Now, what we've seen happen in the last 10, maybe even 20 years is because the media has been changing a lot and has been become less well resourced than it used to be. My impression has been that media institutions have the risk, at the same time as the risk of publishing something in the wrong way has increased because of the development of the internet and other
Yeah.
platforms and so on. The newsrooms have become less well resourced, so there's less people there to keep an eye on things. And often you've got quite young journalists there on their own, possibly not with that wiser, more sort of seasoned person in charge over the top of them. They're having to churn out more stories in 24 hours. They're very pressured. So that care, that need for care has been affected. Those systems that used to exist to make sure that mistakes weren't made or that, things were kept on the straight and narrow has been impacted negatively. And so the risks are greater. And then there's the other thing around media like you, who this growth in sort of small media outlets popping up, doing things online and so on. You're almost all just carrying the risk completely yourselves. So you need to either learn on the job pretty quickly or attend some courses, or I'm not saying you individually need to, but people like you, media like you, carry the risk completely. There are no systems. And right at the top of that pinnacle or near the top is the lawyer. Who's either, retained by the organisation. And that's really only possible for the larger media organisations now because of what it costs. And then it's the editor, finally, who makes the final decision. No matter what the lawyer says, it's the editor who makes the decision and carries the risk. So that person is usually still there. But often now, perhaps they're not getting that legal advice that they might have got in the past. I'm not just saying this to advertise and say that legaling is a good idea and drumming up work for my colleagues. It's a definite thing, a definite real situation that is there and still is there.
No, look, I'm completely on board. I used to work in the mainstream media for talk radio
Yes, I saw
stations,
you
news
did,
and current
yeah.
events. So I've been through a lot of that kind of
You've
training,
seen it,
and we are very, very careful here. Like even right now, I'm about to do it because obviously Mr. Plunket is completely innocent until proven guilty in a court of law, and I'm not asking you to comment on him in particular when I ask this question. But this kind of charge carries a maximum penalty of 3 months imprisonment or a $2,000 fine. What is the nothing to do with Mr. Plunket now, but what is how often does an actual punishment come versus a slap on the wrist and a warning in this sort of situation?
Yeah. I can't answer that question. I don't know. It's quite rare for this sort of charge to arise in any event. As I said, that's probably connected to when decisions are made as to whether somebody should be charged or not, and the way police operate. And I think, as I say, they do try to make examples of people now to try and make the law clear to others. So they can't and they don't charge everybody. They pick out more high profile individuals who appear to perhaps have breached the law, and they, as long as the evidence looks strong and so on, then they'll decide to proceed. So because they are using taxpayers' money, so they have to try and make it stick if they can. And again, like you, as I say, we've got. I'm not making any suggestion at all about whether or not Mr. Plunket has actually committed this offence. He's completely innocent until proven guilty. That's the way the system
Yep.
works. So yeah, that's I don't know how often they decide to. I wouldn't describe it as a slap on the wrist, but
Yeah.
anything down from the in this case, it's the, as you said, the imprisonment for a maximum of up to 3 months and a fine of up to 2,000. Now, that's what we call a minor offence. Doesn't sound like that to ordinary people like you and me. None of us would like to be in
Yeah.
prison for any length of time, of course. Imprisonment, of course, is probably the worst aspect of it. It would be kept in reserve for sort of the worst type of case. And it is only for a period of up to 3 months maximum. Now, all sorts of things enter the picture then, things like whether it's the first offence for this person, what their character is like, any other sort of pleas that, and information that would be relevant to that particular individual. Any judge would have to take those all into account, sort of all together, before they settled on whatever the penalty would be.
Very good. Hey, Professor Cheer, thank you so much for joining me today. I've very much enjoyed connecting with you and learning some more about the system. As we say, we'll leave to the courts what the courts are going to work out and decide, but it is a story that we've been following. So I really wanted to get some clarification on, what it could mean, what it does mean, why the courts do this, why the courts do that.
Sure.
So from the University of Canterbury, Professor Ursula Cheer, thank you so much for joining us.
Thanks, Pat. You're very welcome. I've enjoyed it. All the best.